Welcome back to episode 3 of a 7-part series examining Ontario's proposed modernization of the Private Security and Investigative Services Act, or PISA. In this episode, we're focusing on complaint reform, specifically how complaints are received, assessed, instigated, and resolved, and what those processes mean for frontline fairness, public trust, and public safety. The Ministry has identified concerns with the current complaint framework under PISA, particularly the reliance on mandatory facilitation-only approach for code of conduct complaints. As part of the modernization, the Ministry is exploring reforms that would reduce or remove mandatory facilitation, allow complaints to proceed without complainant participation, expand the ability to investigate alleged misconduct, strengthen enforcement outcomes where appropriate. The stated goal is to ensure that serious misconduct is addressed appropriately and not treated like a customer service dispute. From a frontline perspective, this shift must be handled very carefully. Because security professionals routinely deny access, enforce rules, and respond to incidents involving conflict where there may be a perceived winner and loser, although the actions may be necessary and professionally executed, they result in dissatisfaction from the individuals affected. A complaint system that does not clearly distinguish between dissatisfaction with an outcome and actual misconduct risks becoming punitive rather than protective. So the removal of the facilitation conditional support. From a frontline standpoint, we absolutely agree with one core principle. Serious misconduct should not be minimized or resolved solely through facilitation. We've said it before that not everybody should be in security, and there are people in the security industry that probably shouldn't be there. However, removing facilitation without replacing it with clear safeguards creates predictable risk. Without structured participation or follow-up accountability, individuals may file complaints against security guards in response to enforcement. Then they walk away once the complaint is submitted, and they leave the security professional to absorb the reputational and employment consequences and the workload without any chance of resolution. This undermines both fairness and confidence in the complaint process. The regulatory low-threshold complaints are a real risk. Our operational experience has shown that many complaints arise not from misconduct, but from being denied access, from being trespassed, from having the rules enforced, or incidents where one party feels aggrieved. When complaints are permitted to proceed without participation or substitution, the system risks enabling retaliatory or low-threshold complaints. Consequences are predictable. Increased career risk for frontline personnel, pressure on them to disengage rather than to enforce, and there's greater risk transferred to property and business owners and the general public. A complaint system must not punish good enforcement. The burden of proof must be explicit. A modernized complaint framework must clearly define where the burden of proof sits. From a frontline perspective, it's essential that filing a complaint must not create a presumption of guilt. The burden of proof must rest with the complainant to provide a credible basis or case, and the regulatory to assess the evidence fairly and objectively. Security professionals must not be required to prove their innocence, disprove unsupported allegations, or justify actions absence of any evidence. A system that reverses the burden of proof discourages decisive enforcement, and it undermines public trust and safety. When the complainants are allowed to proceed without participation, it needs to require a higher threshold. Investigations should rely on incident reports, supervisory review, video or witness evidence when it's available, training standards, policy, and situational context. Complaints based solely on dissatisfaction with an outcome should not trigger enforcement action and should be dismissed outright. Moving on to peer reporting. The concept of mandatory peer reporting represents a significant cultural shift. While reporting serious misconduct can be appropriate, any peer reporting requirement must be narrowly defined, limited to serious, clearly articulated violations, supported by strong anti-retaliatory protections. Without these safeguards, peer reporting risks weaponization of interpersonal conflicts or judgment-based disagreements being reframed as misconduct. This will, without a doubt, erode trust within security teams. Reporting systems must reinforce professionalism, not undermine it. Who reviews the complaints matters. If the facilitation is reduced and complainant participation is removed, context becomes absolutely critical. Complaints must be reviewed by individuals with frontline private security experience, or at least they must be allowed to participate in the exercise. Not just people with general enforcement experience, not people with just purely administrative or compliance backgrounds, because they need to understand security-specific decisions, the way security responds under pressure, proportional responses, the difference between assertive enforcement and misconduct in a security context. Complaints reviewed without this frontline security perspective risk penalizing good faith actions rather than improving standards. So our recommendations. These are our initial recommendations. It's not an exhaustive list, and as it's intended to start informed, practical conversations. From a frontline perspective, effective complaint reform should include a clear differentiation between dissatisfaction with an outcome and misconduct, explicit burden of proof standards, higher evidentiary thresholds for non-participatory complaints, early triage and outright dismissal authority for unsupported complaints without prejudice, review by individuals with frontline private security experience. They need to be involved in the process at every step, and strong anti-retaliatory protections for all parties. Complaint systems shape behavior. If the system punishes enforcement, enforcement will decline. If the system presumes guilt, disengagement increases. If the system lacks context, public safety and trust erodes. A fair complaints framework protects the public, the property or business owners, the frontline professionals, and the legitimacy of private security as a public safety contributor. So that's the end of episode 7. In the next episode, we'll be looking at enforcement powers, what authority the registry should have, and why expanded enforcement must be paired with proportional clarity and safeguards. As a reminder, the ministry's consultation period is open until January 21st, 2026. Security Responder will be submitting our comments. We invite you to submit your comments to us for inclusion in our submission or to submit them to the ministry on your own. Remember, frontline voices are critical to this process. We will be bound by these decisions for years to come. We need to make sure that our voices are heard. So everybody, thank you and stay safe out there.